United States Court of Appeals. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, be seated, please. And I'll call the first case. It's a Harwood versus American Airlines. And Mr. Carter, we'll hear from you first.
May it please the court, Adam Carter with the Employment Law Group on behalf of General Thomas Harwood. This court remanded for a fact finding, and all the district court seems to have done is conclude that this court already found that the job was equivalent and appropriate. But this court wanted a fact finding because the district court hadn't done one and declined to do one. So the question now is, can an employer escape liability under USERRA and cut off damages by simply offering a vague job? Look at JA 193. That's the letter from Mr. Key, American Airlines lawyer, to me saying he should go back to the military. He can do that if he wants. We'll employ him. There's no start date. All they say is that he's going to do something that's pay him like a pilot, but doesn't say what he's going to be doing at all.
Is it your contention that your client should be given a chief pilot position?
It's my contention that he should be given the escalator position. We are outside USERRA as of October 22nd. The statute is clear. There's a thing called the escalator position.
Quite familiar with it. My question is, ultimately, are you saying that he should be given this chief pilot position?
I believe that he should be given the escalator position. And that's not the chief pilot position. It's the Boeing 737 captain out of New York. And he doesn't have his driver's license, if you will. That is of no moment.
What do you mean? You mean he doesn't have his medical certificate?
Yeah, yes, sir. The FAA clearance.
Required?
So it's like having a driver's license. It's like having a clearance from the FAA to fly. But that is of no moment under USERRA. The employer brings the veteran home, says, well.
Back that up a little bit.
Okay.
What you're saying is you have to have this requirement under the FAA to have a medical certificate to be a pilot. But that is of no moment to USERRA, because USERRA says you can be a pilot nonetheless.
No, USERRA says you have to do 4 things to get reemployed. This panel, in fact, already determined that he should be reemployed as of September 1. The question now is, what is the escalator job that he's entitled to, and what does American have to do to get him qualified? And that's the point. Regulation 198B says that it restricts the employer from declaring the returning service member to be unqualified. Oh, sorry, son, you don't have your driver's license. You can't be a pilot here. That's not what they're allowed to do. They bring him in from the cold. They say, here's your paycheck, here's your health benefits, and we will help you get that driver's license. That's and American's position is, respectfully, they say, well, that's between you and the FAA. No, it's not. We're talking about the relationship between Harwood and American. They can help him get that. They can pay for it. They can pay for the medical appointments that are necessary. He's got this.
It sounds untenable to me that the FAA would have a requirement for a pilot, which is a medical certificate. You're saying USERRA would require American to put him in that position nonetheless. And I'm just thinking, I mean, who wants to fly as a passenger with someone like that? And then what airline is going to take that level of responsibility or potential liability?
Your Honor, I understand.
If you will.
I understand the problem.
But let me complete it, because obviously you don't, because you seem to be addressing something that, to me, I don't quite understand yet. You're saying on the one hand, USERRA requires it. I understand that. But there's another requirement. The FAA requires something in order for American. American does not. I would not want an airline, anyone else to fly in contravention of what the FAA requires. It could lose its ability to fly, but also it has passengers to be considered. So I asked you initially, is he ultimately seeking a chief pilot position? And got your answer to be no, that's not necessarily what, because that may not fit the escalator position. He just wants a pilot position. Is that right?
He wants an equivalent position after the escalator position. And let me clear up the confusion. When a pilot comes back from military duty, whether, let's say he didn't have the AFib and he didn't have the medical condition, he still couldn't fly on day one. There are things called landing currency. There's training, there's classroom work. There's all sorts of things that he has to do to be up in an airline flying with passengers. And let's look at what actually happened. On January 25th, when he got back, he got his medical clearance. When do you think, Your Honor, he was actually flying passengers in service? Not until April. Do you know why? Because he had to get all this classroom work. He had to do a check ride.
Yeah, but that's not quite fair, because as soon as he got his certificate, they hired him as a pilot.
Correct.
And the pilot with the anticipated he was flying. The preparation to the flying is what you're discussing, and that preparation is necessary for a pilot to do the classroom work and whatever. But what date was that? January 26th or something?
That's right.
He was hired as a pilot.
And all paid. That's the point. You don't need your FAA certificate to get paid, to get in the classroom, to learn how to fly a 737, and to get ready for when the clearance comes. And that's my point, is that you bring the vessel, you don't get to work.
It was inevitable.
It was very likely, given the condition, and it is something that Americans should have had to pay for the work. He should have had to pay for.
Where does it reach the level when, okay, you're not going to get a medical certificate because the condition is so severe it won't happen, to become very likely to, yes, you'll get it? What makes you think this is very likely, and that they should act upon a very likely proposition? And why not just wait until you get it and then go through this training and what's necessary?
Again, USERA requirements, you get your job back. And it does, they can't say you can't come back to work here. And what we're talking about is the position that he should have been in. This panel asked the district court.
Just a minute. We concluded in our last opinion that he could not come back to his job. USERA says if there's has an alternative if he's disabled, and that's what we relied on.
A3. Yes, sir.
And so he was disabled at that point. He could not fly, and as Judge Wynn has pointed out, we don't have to guess whether the medical conditions can be overcome by the FAA or not. So he proposed 4 jobs for acceptance, and they created a job of similar nature, with similar pay, and put him there until he got his certificate, and then they hired him as a pilot.
You asked the district court to do a fact finding whether that job was
just for damages. Just for damages.
Yes, that's right. And the district court did not do that fact finding. And here's the other thing, just to that point, Your Honor, this idea of they requested from us. I mean, the lawyers were just ideating here. What could he do? What would he be interested in doing? That's not the veteran's job. The veteran comes from the military. He doesn't know what all the jobs are that American has. It's up to American
when they proposed the job, they said it was the same pay and status, and they thought it was appropriate. And he turned it down. But then he accepted that job. I didn't see anywhere where he said that's an inappropriate job, or it wasn't equivalent. He accepted it, and of course, the next day he was hired as a pilot. But it doesn't seem like that was an issue below.
The issue for below was whether he should be paid that interim period of time, and the district court made no findings of fact, despite this court's remand. And it was an error for the district court to put the burden on Harwood. Mr. Harwood doesn't have the burden. If this is a rights act, they are strictly liable. And the district court, with respect, said, I'm not convinced. I'm not convinced that the jobs aren't equivalent. The only evidence that the district court had was General Harwood's affidavit. It didn't conduct an evidentiary hearing. And to this day, American Airlines hasn't paid the money that even they say they owe. And so that
an issue before us.
Well,
I would think that as soon as the judgment's final, they'll pay, wouldn't
they haven't paid what we all agree they owe. But my point with respect to the equivalency of the position is the district court made no findings with respect to status, with respect to his joint collective bargaining agreements. When was the start date? Look at JA 193. Is there a start date? Is there a direction of who he's supposed to go report to? Is there anything about his bargaining rights? What happens, in fact, to Judge Wynn's point, what happens when he does clear FAA waivers? And they brought him back to this position in Dallas. He now says, I want my pilot position. And American says, no, you've got this equivalent position. Now we're not going to put you in that. We don't know at this point if he accepts this job. To Judge Niemeyer's question, if he accepts this job, what's to say that they can't keep him there? His rights, as for USERRA, have to do with the escalator position, and that was what he was intent on. The fact is that when his wife wasn't well and he needed the better American Airlines benefits, that's what caused him to pick up the phone, call, and then there was a little bit more play about what the job was, what it would involve, the fact that he could go to Dallas and get a ticket to get there. None of those things are set forth here. Let me just say a word about the attorney's fees before I close. It is well settled law that the attorney's fees should be at current rates. For the district court to, and the late great Rick Seymour, who worked on this case and who built on this case, the idea that someone of his stature would be bucked down to $450 an hour. And by the way, who's paying that? Who's getting cheated out of that extra hour? Not the lawyers, Your Honor. My client paid that $450 when the bill was due. He's been paying an hourly client all along. And the time value of money on attorney's fees is at current rates. And the current rates that were not applied by the district court said that it was going to apply $450 an hour for principals rather than the Vienna Metro Matrix that had been accepted. And those hours were at $450. And the fact that they are paid shows that that's the market rate, but it should be at current rates. That's what the time value of money is. We don't get interest awarded on an attorney's fee petition. So that was also an error. I'll reserve the rest of my time unless the court has extra questions.
Well, let me ask you, what would you have us do?
I would have, Your Honor, remand back to the district court and ask for a fact finding to hold an evidentiary hearing. The district court had ordered cross briefs of 20 pages.
What facts do you want the court to find?
Well, I want the court to find that what was the job that Mr. Harwood was going to be going to, and what was the evidence of what was there at the time, and all of that, and then decide, okay, is that equivalent to a 737 pilot in New York? Yes or no? And if it is yes, then okay. And then if it is no, then award the damages for not having done that before. This is a communication lawyer to lawyer. Nothing stopped American from calling up Harwood and saying, get down here to Dallas. We're going to pay you. We're going to keep your benefits intact. They didn't do any of that.
All right.
Thank you, Your Honor.
Yes. Zarrow.
Good morning, Your Honors, and may it please the court. Jason Sarah on behalf of American Airlines. I'll start with the suggestion that the district court in this case didn't make the fact finding that this court required of it on remand. The district court specifically found that the position that American offered came with the same pay and benefits that Harwood received as a pilot, plus equal status within the organization. That's the fact finding this court remanded for, and that's the fact finding the district court made, and that's at JA 834. With respect to Mr. Harwood's suggestion that there needed to be an evidentiary hearing, Mr. Harwood did not request an evidentiary hearing on remand to the district court. And on top of that, there weren't any disputed facts that would justify an evidentiary hearing. Everything in this record, I mean, it speaks for itself. It's not as if there needs to be testimony to determine what American offered, what it said about the benefits, about the pay, et cetera, et cetera. So I think the suggestion that there needs to be a remand for an evidentiary hearing or the district court didn't do what this court suggested is plainly incorrect. I heard Mr. Harwood argue that American should have rehired him into a pilot's position, put him on the payroll, and then transfer him, I suppose, to some other job later if he didn't ultimately receive a waiver from the FAA. But I think this court actually already resolved that contention in its prior opinion. Judge Niemeyer, you asked a question about this, but the court said at page 417, it's clear from the record that Mr. Harwood was not qualified at the time he presented for reemployment for his escalator position as a pilot. The court also said that returning service members must be promptly reemployed in an appropriate position for which they are qualified.
Well, I thought the question before the district court would be, because at the time he couldn't get clearance to fly. So the question was, if he can't be hired as a pilot, what constitutes an equivalent position? Is that what the court did?
That's exactly right. The district court evaluated whether the position offered on October 22nd, 2015 in the Flight Technical Operations Group in Dallas was an equivalent position, or rather the nearest approximation to Mr. Harwood's pilot position under 4313 B, subsection B. That's exactly what the district court did. And the district court found that it was equivalent. And the court found that it was the nearest approximation to an equivalent position precisely because, as I said earlier, it made fact findings that the position came with the same pay and benefits plus equal status within the organization. This court will find the facts supporting the district court's fact finding at page 490 of the record, page 367 of the record, and page 299 of the record. And I submit there's no showing here of clear error, and that's the standard of review for that finding, much less any error at all.
October 22nd letter, insofar as the question of seniority, it doesn't seem to mention that.
I believe the October 22nd letter said it would be appropriate for his status and came with the same compensation that he would receive as a pilot, correct? I don't think it mentioned seniority in particular. I think those details were later fleshed out. I think ordinarily that seniority when it is something like, for example, if Mr. Harwood was a pilot at seniority of level 7, and he would have become a pilot seniority level 9 on return from his military service, it affects bidding for what type of flights the pilot's going to get. But this was an entirely different job. I mean, it was a change of position. He went from a pilot to a non-pilot. So I'm not entirely sure how that type of seniority even translates in this case. Mr. Harwood's suggestion, perhaps, is that he needed to get the rights under the pilot CBA. I mean, that may be the argument about seniority. And if that's the argument, I would direct the court to JA page 490, where American explained that Mr. Harwood was going to receive the same types of rights as he would have received under the joint collective bargaining agreement.
Well, I was just mentioning it because the USERRA does require that there's some equivalency of the seniority. And that just seems it's not that clear in that letter. What about the accrued sick leave benefits? Wasn't he entitled to that? I didn't see that in there either.
Right. So that, Your Honor, I would direct the court to page 490. This is the second letter from American where it spelled it out in greater detail. This, I think, dovetails with Mr. Harwood's argument that the offer was not sufficiently specific. And of course, the record actually shows that he would have received, for example, accrued sick leave benefits. But the argument, I think, is that the October 22nd letter was too vague or not sufficiently specific. And I think there are at least 3 reasons, if not more, to reject that argument in this case. And the first is that American offered Mr. Harwood exactly what he asked for. As Judge Niemeyer noted, there was a letter from Mr. Harwood's counsel on October 1st that said, here are 4 jobs that we're interested in. One of them was flight operations within the flight group in Dallas. And that is precisely the position that American offered. The second point, as Mr. Carter referenced, is this was a conversation between attorneys. It was not a conversation between an individual unrepresented and his or her company. This was a conversation between attorneys. And so the suggestion that there weren't enough specifics in the letter rings a little bit hollow to me, because if Mr. Harwood needed more specifics to figure out whether or not to take the job under USERRA, all he had to do was ask. But instead, what we have in this case, respectfully, is we have the record shows that Mr. Harwood declined the job on advice of counsel, and then turns around and sues American and says the offer is not qualifying, precisely because there weren't specifics, when of course Mr. Harwood was represented by counsel and simply could have asked. And had he asked, he later did ask in January of 2016, had he asked, he would have received the same letter that American sent back, which said, here are all the benefits that you would get: sick leave, relocation pay, pension, et cetera, et cetera. And there would be no argument in this case about specificity. So I think, with all due respect, it's a little bit of a gotcha. The third point, of course, is in terms of the scope of job responsibilities. American was creating a brand new position from scratch for Mr. Harwood. He was a pilot. He was qualified to be a pilot, but for the medical certificate, and it was creating a desk job for him. And this is a highly unusual circumstance. So, as Mr. Hansen, the director of flight operations, testified in this case, what American wanted to do was confer with Mr. Harwood about the scope of the position. I mean, it really, truly was making a position here from scratch. But of course, Mr. Harwood did not confer with American. He simply rejected the job on advice of counsel. And then my last point, this is the fourth point, is I think this argument as well is barred by the mandate rule. As I understand Mr. Harwood's argument, it's that the October 22nd job offer did not qualify under USERRA, even if the job came with the same seniority status and pay. So the job offer itself was defective, but this court's remand order told the district court to evaluate seniority status and pay. And that would, of course, have been pointless if the offer was simply defective because it lacked specifics. So I think for those 4 reasons, this court should reject the specificity argument.
Does that go to your opposing counsel's argument that, well, he didn't have to be made a pilot right away, but American should have started the training and begin the whatever procedures in anticipation that he very likely would get this medical certificate?
Right. So I think that argument certainly has the benefit of hindsight. At the time, nobody knew if Mr. Harwood would or would not receive the waiver. But I think this court actually already resolved that question. The argument from Mr. Harwood is, you should have hired me as a pilot and then let me train until the FAA made a decision at some point in time. At the time, nobody knew when that would be or what the decision would be. But this court said American was not obligated to hire Mr. Harwood as a pilot. So I think that argument is simply barred by this court's prior opinion, not just the mandate rule. I think this court expressly rejected the argument that American was required to rehire him as a pilot and then train him. And if this court was to go any further than its prior opinion and just look at the merits of the argument, I think it would reject it. It should reject it as well. And the reason is, when a company is rehiring an employee under USERRA, they need to be qualified to perform the job. And Mr. Harwood was not qualified to perform the job of pilot. So even if they had rehired him as a pilot and trained him, it still would be true that he was not qualified. The training wouldn't have affected his qualifications. In terms of the key disqualifying feature, which was the first class medical certificate, as this court held in its prior opinion. I also heard Mr. Harwood's attorney argue that American did not make efforts to reasonably accommodate Mr. Harwood's disability. I think that argument is also barred by the mandate rule. There was extensive argument before the panel last time about that, and this court remanded only for a finding on the seniority status and pay question, which the district court did. And Mr. Harwood's argument is, again, just like with the specificity argument, is that those findings were unnecessary or beside the point because American's offer was defective as a threshold matter because American did not first try to accommodate Mr. Harwood. So I think the court should reject that argument as well. If there aren't any other questions about the October 22nd, 2015 offer, and I'm happy to address any that the court might have, I will move briefly to attorney's fees. I think the court should affirm the district court's attorney's fee award in its entirety. What we have here is a routine exercise of discretion, not an abuse of discretion. Mr. Harwood addressed one issue. I think there are 6 in the briefs. I think they're adequately covered in the briefs, but he brought up one issue, which is that the district court should have compensated Harwood's counsel at current rates. And I want to be very clear about the factual posture of that argument because I think it illustrates precisely why the argument is not meritorious. In the ordinary course, an attorney might perform work, say in 2015, 2016, and 2017, prevail or prevail in part, and then submit a fee petition in 2018. It would be reasonable in those circumstances, I agree, in 2018 to say my work in 2015, 16, and 17 should be compensated at 2018 rates to account for cost of living adjustments and inflation. But that's not what happened in this case. Mr. Harwood's counsel didn't say I should be compensated at 2018 or 2019 rates for the work I did the past 3 years. What Mr. Harwood's counsel said is I should be compensated at 2011 rates because effective rates have remained static for the last 7 years, 6 or 7 years, 2018, 2019. So instead of saying, district court, you should give me current rates to reflect cost of living adjustments and inflation, Mr. Harwood was arguing effectively there was no inflation, there were no cost of living increases. You should give me the rate in 2011. That's on the first fee petition. On the second fee petition, and this was after this court's remand decision, Mr. Harwood's counsel specifically asked for $450. He didn't ask for $450 trued up to 2020 or 2021 rates. He asked for $450. So the argument, as I understand it, is that the district court erred in not sua sponte increasing the fee award. In the first fee petition, it was a request for 2011 rates. In the second fee petition, it was a request for the exact rate that the district court awarded. And I don't think Mr. Harwood can show an abuse of discretion where the argument is the district court sua sponte had to ignore what Mr. Harwood's counsel was arguing for before the district court, and then sua sponte give a cost of living and inflation adjustment. I don't think in any way that that's an abuse of discretion. Had Mr. Harwood's counsel asked for the higher rates that he's complaining about now, perhaps there would be an argument, but that's just simply not what happened in this case. Again, he asked for 2011 rates in the first fee petition, and he asked for the exact same rate that he was awarded on the second fee petition. That's not an abuse of discretion. If this court has questions about other aspects of the fee award, I'd be happy to address it. Otherwise, I think it's adequately covered on the briefs, and I would cede the rest of my time.
Thank you, Mr. Zarrow.
Thank you.
Mr. Carter.
Thank you, Your Honor. With respect to the equivalency position, it was the nearest approximation. Let's all be very clear. There is a 3-step approach in USERRA. The first job is escalator. You have to bring him back to the escalator position and get him qualified for it. That didn't happen. The next level is equivalent position. Bring him back to equivalent position, get him qualified. That didn't happen here. Nearest approximation is the third rung. That isn't even before this court. So let's be clear. The next point that my opponent makes is this point about the mandate rule. With respect, this court asked the district court to make a fact finding, which it didn't do. It simply referred back to this court's word, the word appropriate, that it was an appropriate position. So the district court took it as given that the October 22nd was appropriate. And Your Honor, Judge Wynn, your question about seniority, is very insightful. That is a problem. You look at JA 193, there's nothing about seniority. There's nothing about health benefits. There's nothing about a start date. There's nothing about the exact pay. And my opponent says, look at page 490. I agree.
Can I ask you how we're to handle the letter where the American Airlines laid out all the specific benefits, pension rights, benefits?
I was just going there, Your Honor. Thank you. That date of that letter is January 16th. That's 10 days away from January 25th when all this went down. So if this court wants to,
right?
I'm sorry?
Before he accepted the position?
It's just slightly before. It's 10 days.
I know, but it's before. In other words, he could have rejected the position because it wasn't equivalent, but it's now being laid out, the details of his benefits, pension plan and this type of thing. And then he accepted that position, right?
Quite so. And my point is that to cut off damages at the vague email from lawyer to lawyer as of October 22nd, and not to put it at least at January 16th in 2016 is a clear error. With respect to the attorney's fees.
Let me ask you, because it was a lawyer to lawyer, did you ask those details to be put in the letter?
Well, the answer is no.
Why? You're asking us now, you're very clear as to what should be in there. Why wouldn't you just say, I want these details in the letter?
And I'll tell you why. It was because of the initial, we were already outside of USERRA. I was already concerned that we were outside the law. The law says that my client doesn't have to do anything. He waits for the employer to bring him back. And they have not done that. Nothing stopped them from communicating with General Harwood and saying, General Harwood, come back to this position on this date. They didn't do that.
I'm having some difficulty understanding. These are lawyer to lawyer, and you're saying an offer is made by the company, and you don't have to do anything except look at the offer and not make any suggestions. Don't say, well, you didn't mention seniority. Or you didn't put this in there. And you can just continue to go along, come to the court as though it's the first time ever the offer has been made in court.
Your Honor, there is nothing in USERRA about the employee having to engage with the employer about and finalize all the details.
Nothing in USERRA that says you got to have lawyer-to-lawyer negotiations, period. You don't need the lawyers in it. So, but once you get them in it, you have something to do, don't you? I mean, you want to be paid this fee. What is the fee worth if you don't get in and negotiate and do something? Why even? Maybe that's too much if you're just going to say, well, just make an offer and we'll go to court and complain that you didn't put in this and you didn't put in that, but we never mentioned it. Is that fair? I mean, is that a fair statement?
Well, Your Honor, ethically, I can't get into what were going on in the settlement discussions and all this, but the parties were having robust settlement discussions.
I only asked, did you ask for those things that you're complaining about today that are not in the letter? I understand. I don't want you to get into the negotiation, but you seem to think those are important things. And I'm wondering, why didn't you ask for it and just before?
Well, I'll just say it didn't occur to me that the idea that when Mr. Key wrote on January,
you sir required it. Why wouldn't it occur to you that seniority is something that you ought to have in the letter, that you ought to have accrued benefits? What do you mean it didn't occur to you? I don't understand that.
It didn't occur to me that we were talking about equivalency. We should have been talking about the escalator position and then re-employing him promptly. Remember, we didn't have the benefit of this panel's earlier decision. I notice I'm out of time. I just wanted to say one thing about attorney's fees, if I may. And that is with respect to not asking for them. That's just not right. We did ask for the higher rate, and the district court knocked it down from 563 to 450. Thank you, Your Honor.
Thank you. Would normally come down to Greek counsel. That's one of the iconic practices that we have on our court. We're proud of it, and it's been done since the 1930s. And it took the pandemic to suspend it for a little while. So we're going to continue to observe that type of protocol.
We'll do a virtual.
But we do appreciate counsel's arguments. And when you come to court next time, we'll give you a firm handshake and make up for it. Thank you very much, and we'll proceed on to the next case.
Thank you.
Versus Morehouse. And Ms. Biederman, or Bitterman, I'm not sure how you pronounce it.
Biederman, you got it right.
All right. We'll hear from you when you're ready.
Thank you. Good morning, Judges Niemeyer, Wynn, and Floyd, and may it please the court. I am Donna.
Let me just say to you, if it's your pleasure, you're welcome to take your mask off while you're arguing.
Thank you.
Don't do so if you're not comfortable. It's up to you.
Thank you.
Yeah, sure.
Might be easier to understand. I am Donna Biederman, and I represent the appellant, Jonathan Kyle Morehouse, in this case. Mr. Morehouse is a 10-year veteran of the U.S. Army who is educated, married, and a devoted father who had absolutely no criminal record at all until his arrest in this case. After his second deployment to Afghanistan, where he regularly witnessed all sorts of terrible things, including firsthand mortar attacks, trauma to Army service people, and the deaths of service members, he suffered from PTSD, anxiety, insomnia, nightmare, depression, flashbacks, and physiological symptoms.
So we got a couple of issues in this case, and all that you're saying is relevant, and I feel for it in terms of the military service having dealt with these kind of cases. It seems like the number is disproportionate military personnel to be dealing with pornographic images, but we won't need to deal with that. There's a question of whether this 2-point enhancement is appropriate and whether the 5-point enhancement is appropriate.
Correct.
I would think that you probably would move to the 5 because that 2 level, at least to me, looks like you waived that one. But you can argue otherwise.
I don't believe we waived it, but I would like to start with the 5-point enhancement if we could.
Why don't you go ahead and deal with the one that looks like to me is dispositive, and then go to that one. Because you need to get me off of that. At least me.
Okay, I'll tell you why I believe we did not waive that. What happened is the 2-point enhancement. What happened with the 2-point enhancement is that they had an agreement that it was under 10 pictures, and that that was part of the statement of facts. Then they go to the hearing, and the government, for the first time, is now arguing it's over 10 points.
Yeah, but you're just collapsed two different procedures. When you take a guilty plea, the court has to have a statement of facts sufficient to accept the guilty plea. We don't want to be having persons pleading guilty to where there's no basis of fact for it.
Correct.
And so there was a statement of facts agreed to for that purpose.
Correct.
When it comes to sentencing, the court is entitled to look at relevant conduct. And that doesn't mean that the statement of facts limits. The statement of facts is sufficient to accept the guilty plea, but the relevant conduct under when sentencing can go broader, and that's what the court did, right?
Yes.
You can try to address why that isn't perfectly sufficient explanation for that.
I will be happy to address that. I would like to finish with whether he waived it and then move on to that, if that's all right.
I'm sorry. Go ahead.
Thank you. When they get to the sentencing, he's given a choice, and the choice is either you don't argue that this is wrong, and then we give you 3 points for not accepting responsibility, or you say, okay, I'm not going to argue it's wrong, and get the 2 points. He was given a catch-22. He was given if you are going to not waive this, you're going to be in a worse position. It wasn't really a conscious choice or a free choice, because if he didn't agree not to discuss it, not to argue it, then he was going to be in a worse position. And that's why we don't believe it was an actual waiver. As to Judge Niemeyer's question, the statement of facts does say that this is enough to make it sufficient for the charge. But it doesn't, but what it said there is that there were less than 10 pieces. It didn't say of pornography. It didn't say there are about 10 pieces. There could be more or less.
Read the language. What did the language actually say?
Court's indulgence.
Well, if it takes it, I don't want to take all your argument time.
I can pull that up and do that during my rebuttal time. But I did look at it again last night, and I know that it said less than 10. And I looked to see if there was any sort of a reservation, and there was not.
What I was trying to find is that, was it a limiting fact? In other words, he did no more than 10. Or yes. Did it say he did at least, or he did 9 or less than 10? If he just did less than 10, that supports the claim. But when you come to sentencing, as you know, that doesn't have to be part of the facts of conviction.
Ms. Bitterman, I think the record shows that his counsel specifically asked the PCR to say 10 or more images. It wasn't the government, it was his lawyer.
I don't believe that's correct, but I will check and address that during my rebuttal time, if that's all right with your honors. I would like to move on to
119 will help you out.
I'm sorry?
AA 119.
Thank you. I would like to move to the 5-point enhancement, which is the major part of our argument here. And that has to do with whether he satisfied the statute and the enhancement, the 5-point enhancement under the current rules. In 2016, there was, excuse me, an amendment to the rules which changed.
You just want us to follow the Sixth Circuit decision and all of them.
Not necessarily, but I do think the Sixth Circuit decision in Oliver sets it forward correctly. But what the Fourth Circuit decision in McManus and the Fifth Circuit decision in Gross were both before the amendments, and they both had to do with intent, which is no longer what we are looking at. We are now looking at whether there is an exchange for one thing for another with a person, with a specific person. And there's no evidence at all of any of that. The evidence is that he uploaded some pictures to the internet. It was mentioned that it was a closed upload on Snapchat. There was no understanding of what that was or no explanation of what a closed upload is. I don't even know if that means that it's not available to other people and only to him or not.
I don't understand when you say not necessarily Oliver. McManus gave you two factors that are there. Oliver's indicates there's another factor that deals with agreement there.
Right. We agree
What is it
with
about that not necessarily you would espouse for your position?
No, there's nothing in Oliver that I don't espouse. You said you just want us to follow Oliver, and I'm suggesting that Oliver is a good framework for this court. I think Oliver is correct. I didn't mean to suggest otherwise. And if your honors want to just follow Oliver, that's fine, because that's the only case we have that explains what this is after the change to in 2016. But that is a good framework for us, absolutely, because that is the one that talks about what happened after 2016.
From the Fourth Circuit law that you're dealing with, and because you got a recent amendment to this here, and that's really what we're talking about. I don't know if we've got cases dealing with that recent amendment there. Oliver does. Halberstam out of the Fifth Circuit does to a less extent. I'm trying to understand, how would you change it? What do you mean when you say that doesn't, it's a framework to work with, but it's not, you seem to indicate it's not the best one, and you have a better one.
No, I don't.
What's the better one you had?
I would follow Oliver. I just didn't want to tell your honors that you needed to follow another circuit court exactly. But that, I think the Oliver framework is correct.
Follow it exactly if we don't want to. It's a circuit court decision just for guidance. We don't have to follow it at all.
Yes.
We can go completely opposite of Oliver.
Absolutely.
What you would like us to do.
I would like you to follow Oliver.
Well, let me ask you.
I think Oliver is correct.
You need is it your contention that the government needs to identify the person with whom your client communicated?
So you don't need to necessarily identify the person exactly, but there needs to be a person, and they need to know that there is this person, and whether they know his name and address is not of moment here, but whether they know that there is a person with whom he exchanged, that's important. So it can be an unidentified person, but there has to be a person. If, for instance, if you upload something, and then you just download something else, there's no person that you have had an agreement with in that case. And there's no exchange with another person. Just because he downloaded some images and just because he uploaded some images, there's no evidence that there was any kind of agreement with somebody else. And there's no evidence that there was somebody else with whom he made this exchange. So he could have just uploaded and some people could have seen it, and then he could have downloaded something else. And there's no evidence that the person that or people that he downloaded the images for had ever seen his, or that had ever done it in exchange for having seen his. So the fact that he did some uploads and that he did some downloads do not mean that he had an agreement with another person to exchange those, and that he actually did exchange those, which is what's required under the amendment.
Is his admission that he did this to get more pornography, is that sufficient to support the valuable consideration prong?
If you're talking about the catch a predator thing, then no, it's not, because what happened here is that when he was arrested, he first said, in his panic at getting arrested, he first said it was inadvertent. He then said he was doing it as a catch a predator, which nobody believed. He then took that back and said, that is not true. I am addicted to porn, and I was looking at this pornography. Nobody believes, first of all, that he actually was trying to do a catch a predator. And if there's a child pornographer's handbook, that would be in there to say, oh, I'm doing it to catch a predator. It's something that a lot of people say, and that is almost, and is really never
when he puts it online.
Mm-hmm.
If he's just addicted and that's the whole thing, he would be only downloading, but he put it online. And I think the district court found he put it online with the expectation is that he would get more coming back at him.
The district.
And your argument, I think, if I understand it, is the mere expectation from a site is not enough in lieu of 216 amendment, that he has to have an exchange, which the commentary says is an agreement with another person to receive something back. It's subtle, but in the first case, he has an expectation from a general site that he's going to receive some in exchange. And in the second, he has an agreement with someone to an exchange. Is that roughly where we are?
Yes, that's exactly where we are. Yes. He has to have made an agreement with another person to exchange, and there's no evidence that that happened at all.
Well, I don't know if we have to decide whether there's evidence on it. Well, maybe we do.
I think we do. And there's not even a suggestion of that. The only suggestion is that, or evidence or anything here in this case, is that he uploaded some and he downloaded some. And there's nothing connecting the two of them. And there's nothing showing any sort of an exchange. And there's nothing showing any sort of an agreement with another person.
What about his admission?
His admission being the catch a predator admission. It's
No. To get
that he was hoping to get it. That has to go to his intent, which is specifically what the 2016 amendment changed. What you're calling an admission that had to do with his intent. To me, that might have been sufficient had it been before 2016. But the 2016 amendment specifically went to change that and to say that's not enough. That 5-point enhancement is for an actual agreement and an actual exchange and not just an intent. So it's no longer supports it under the amendment. The amendment actually says the defendant distributed in exchange for any valuable consideration means the defendant agreed to an exchange with another person for the specific purpose of obtaining something of valuable consideration from that other person. And we don't have any suggestion of any other person that would be. He didn't agree with anyone to exchange pornography. There's no evidence that he did exchange pornography with anyone. There's disparate acts of receiving and uploading, but nothing connecting the two of them. There's no consideration. There's no mutual understanding. There's nothing here that would satisfy the statute as now written after the 2016 amendments. There has to be more than just a generalized expectation that because of the way the online chatting systems work, there might be something that comes back in exchange. There has to actually be something that comes back in exchange, and we don't have that here. The district court, by the way, agreed that there has to be something more than that sort of generalized expectation. But the district court did say perhaps it was his goal, perhaps it was not his goal, that to get something in back. We don't know if it was his goal. And that's what the government was arguing too, that isn't any evidence. We don't really know whether he really meant this or not. And that's not enough for an enhancement, because for an enhancement, you need to have sufficient indicia of reliability. And here there's no indicia of reliability on that statement at all. I mean, the government didn't believe it. The investigators didn't believe it. The defense said took it back, said it wasn't true. The judge suggested that he had no idea if it was true. And that's not sufficient indicia of reliability in order to have an enhancement. If there are no further questions, I will reserve the rest of my time for rebuttal.
All right, thank you. Mr. Ossoff.
Thank you and good morning, Your Honors. May it please the court, Peter Ossoff on behalf of the United States. Mr. Morehouse's sentencing guidelines were properly calculated.
I offer, if you want, I really don't want to press you. I mean, if you're uncomfortable with it, wear your mask.
No, Judge, I thank you for the reminder. I'm very happy to take it off. May it please the court, Peter Ossoff on behalf of the United States. Mr. Morehouse's sentencing guidelines were properly calculated, and his 84-month sentence, consisting of a 13-month downward variance, was reasonable. Mr. Morehouse raises two issues on appeal. The first, I'll briefly address in regard to his enhancement, 2-point enhancement under sentencing guidelines, section 2G 2.2 B7A. As Judge Wynn pointed out, Mr. Morehouse waived the right to appeal this issue on multiple levels. First and foremost, there was no agreement whatsoever between the parties. There was no plea agreement. He pled straight up to an indictment. And in the joint appendix at 21 and 24, the Rule 11 colloquy, this is emphasized multiple times by the magistrate judge who took the plea, emphasizing that there was no plea agreement, no other offers made at any time to the defendant, which was confirmed by the defendant's own words and his counsel at the colloquy.
What is the catch-22 position Ms. Biederman contends her client was put into, such that this in fact was maybe a withdrawal, but it wasn't really, it was kind of a coerced type thing?
So Judge Wynn, I believe what she is referring to is in the statement of facts, which is in the JA at 204, in the recitation of the statement of facts in the PSR. Paragraph 11 of the statement of facts said, less than 10 images depicting child pornography were observed to be on Morehouse's cellular phone. Now, I urge the judges to look at the statement of facts and see that paragraphs 8 through 12 of the statement of facts are all in reference to the October 6, 2019 seizure. It specifically emphasized that there were less than 10 images on his cell phone at that time when agents took a look at it. However, as always, in the end of the government statement of facts, paragraph 16 of the statement of facts found in the recitation, the PSR and JA 205, Morehouse further acknowledges that the foregoing statements of facts covers the elements of the offense charged, but does not describe all of his conduct relating to the offenses charged in this case. There's further no objection to paragraphs 8 or 9 in the PSR found at JA 206 and even in the revised PSR 268, where it references additional 5 images from cyber tip reports and an additional image of child pornography on his HIC account. There was no deception on any part that there were additional images that were attributable to the defendant. And again, there was no agreement otherwise. This idea that the statement of facts, that one paragraph that specifically says there were less than 10 images on his cellular phone, particularly at the time of the search warrant, is just not applicable. Further, Your Honors, paragraph 16 of the statement of facts, I already went through that part. Further, Your Honors, in defendant's own sentencing position paper at JA 62, Mr. Morehouse is withdrawing his objection to the 2-level enhancement pursuant to U.S. Sentencing Guidelines Section 2G 2.2B7A. Ms. Biederman suggested that he was somehow doped into a new predicament at sentencing. This is clearly not true, as evidence from his sentencing position paper prior to the sentencing hearing, where he waives his objection. And finally, at the sentencing hearing in the joint appendix at 119, defense counsel states, could we just simply say that he was in possession of 10 or more images? And that was because there was some dispute, and the defense counsel goes on at sentencing to say there was some dispute as to the specific number, but it was not in dispute that he fell within that 10 to 150 images. For those reasons, Your Honor, the 2G 2.2 B7A 2-point enhancement was proper. Moving on to the second enhancement, the 2G 2.2 B3B, the government concedes that the McManus test was clearly established in 2013. And afterwards, in 2016, there was the 801 amendment to this particular enhancement. However, the government's position is the McManus test is still good. In fact, we know this because in the sentencing supplement to Appendix C in the amendments to 801, which both parties recite in their briefs, appellant briefs and appellee briefs on page 17 of both briefs, actually, recite the explanatory note for the 801 and the purpose of it, where the commission juxtaposes the McManus position in a positive light with the gross Fifth Circuit Gross case, which was more of the Fifth Circuit Gross case was more of an inherent reciprocity or a per se rule that they had adopted. Essentially, any defendant who allowed access to his child pornographic material where people could access it and exchange it, if that was sufficient enough, and this court, in its forward thinking, said, no, that's not okay.
Yeah, but that's not a substitute for what McManus actually said. And I read here, McManus said, a thing that is expected is reasonably likely to occur. And the idea is here, and they also said, it's expected when he distributed his files on his belief that he would receive something of value in return. So McManus basically followed a proposition that the expectation of consideration is enough, and that if you put it on a site where people exchange pornography, that would be enough. But I see a subtle difference between that and the 2016, especially when you read the commentary that says it envisions an agreement between the defendant and someone else for the exchange, specific exchange. And they change the language from expectation to expect an exchange. And so I don't know if you accept a difference between the statements of McManus and the 2016 amendment, but it seems like there is some difference there, despite what you're reading there in the background.
Your Honor, I believe there is some difference, but it's subtle, and I think there's evidence.
It is subtle. I agree with that. Yes,
and I think there's evidence that the commission's intent, in fact, the application note was essentially modeled after this court's ruling in McManus. There's nothing to suggest in the plain language of the application note that a contract-like meeting of the minds.
No, but what to say? What's the verb? It says that the defendant agree, isn't it? Something I don't have it.
Agreed to an exchange, Your Honor. The amendment reads, the application note reads, the defendant distributed in exchange for any valuable consideration means the defendant agreed to an exchange with another person, under which.
Well, that's the clause that gives me pause. Mm-hmm. In other words, an agreement of an exchange with another person. Whereas McManus allowed for the possibility that you have an expectation because you're putting it on a site from which you reasonably could expect a return.
And Your Honor, I would urge the court to look at, again, why the commission decided to make this amendment. And it was not to emphasize that there needs to be an exchange.
Why do we have to do that if it's pretty plain in front of us what they say?
Well, Your Honor, I
examine why they did something when they say agree with another person. McManus, as Judge Niemeyer is pointing out, is dealing more with the expectation of receipt. I mean, we the commentary can be useful in other purposes, but it's right there in front of our face. And we are not alone, at least in terms of the other side. That you have the Sixth Circuit case. They read it just that way too.
I understand that, Your Honor.
There's the Hamilton case out of the Fifth Circuit that went also to say there's something additional that was done here. It's pretty plain that there is a difference in McManus and the case that we have here. McManus is clearly dealing with expectation, and now we have this language for whatever. It could be for a purpose. I don't disagree. I'm not sure they intended this or whatever, but we're court. We go by what the language says, and we don't try to go and look behind purposes of things. And you don't want us to do that, because even when you bring a case, you don't. If a statute is reading a certain, you don't want to, when you're seeking to prosecute a case, to say, well, let's look at the purpose of it instead of what the language actually says. I know this thing goes both ways, doesn't it?
I understand, Judge Wynn, and as a textualist, I adhere to the language of the application note. And I would urge the court to consider that if the emphasis was to be on an agreement, It could have much easier and much clearer could have read, the defendant agreed with another person to distribute in exchange for something of valuable consideration from that person. It doesn't. It goes on to say that there has to be, the operative word is that the defendant knowingly distributed for the specific purposes of obtaining something of value. Again, I believe the court in McManus was the catalyst for this change from the commission. And the
Sixth Circuit and Oliver wrong about this then?
Yes, Your Honor, but
about the Fifth Circuit, were they wrong in Hamilton about it too?
I don't believe the tests established in Halverson and Oliver are necessarily wrong. I do believe that the appellant's suggestion that this creates some sort of inculpatory meeting of the minds of a specific additional person.
I don't know if you have to go that far. It seems to me the commission was clearly intent on making a change when they took out the word expectation and said expect and more specific. In other words, there has to be a more focused specific, and the commentary explains why they made that change. And instead of an expectation by sending child pornography up to a site where there is generally exchanging going on and expecting to receive an exchange in front of it, he puts it up and he knows that somebody's going to say, hey, that's great stuff. Here's some of the stuff I have too. That's an expectation, which could imply some kind of agreement, but it's pretty general. And so it looks to me like they were tightening down on it and saying the general expectation wasn't enough. We want a particularized expectation from an agreement with another person. That's a little tighter.
I would understand and agree with that, Your Honor. And I don't see expectation in the new language.
It uses the verb expect, right?
No, Your Honor.
I forgot.
The application note, are you referring to the application note?
No, I was reading the guideline.
The guideline itself says if the defendant distributed in exchange for valuable consideration, but in exchange.
Correct. Distributed in exchange for.
Correct.
And the earlier one used the word expectation. Distributed for the expectation of receipt of a thing of value. So that was too general for the commission, and they said you have to distribute in exchange for. And then they explained that that means that it's distributed with an agreement with another person.
I would agree with that.
Agree with it's subtle, but there's a difference. They intended some difference.
I agree with you, Judge
McManus interpreted the former.
And I think the two-part test in McManus touched upon that subtle.
No, McManus basically talked about a sort of a subjective belief. It said to distribute his files on the belief that he would receive something of value in return. A thing that is expected is reasonably likely to occur. Your Honor, that's they were focusing on expectation, whereas the new rule talks about really focusing on the exchange, agreed upon exchange. And maybe you don't agree, but that's my trouble.
So, Your Honor, I concede, and I don't have it right at my fingertips. That may be the part of the dicta in McManus, but the
holding, isn't it?
The two-part test established in McManus is one, knowingly made child pornography in his possession available to others by some means, and two, made his pornographic materials available for the specific purpose of obtaining something of valuable consideration.
Well, but then they explained exactly what I said right after that. We explained right after that what that means. And we said right after that, he has to have a belief that he would be receiving something of value. And then we go on even further to explain that belief has to be a reasonable belief.
Correct. And Your Honor, I think regardless, we meet that test here by paragraph.
You do.
Yes, Your Honor.
Court so found. But the argument here today is not that you meet the McManus test. The argument today that I believe is being made is that there was a change in 2016 and that the change has not been satisfied.
Well,
go ahead. Yeah.
The quote attributable to him is that he shared material in order to receive other material from unidentified users. Is that enough?
Yes, it is, Your Honor. That statement, which goes to, unfortunately, Your Honors, the record here is thin because it was that we don't have the luxury of having a trial with a record. We essentially have the statement of facts and the adopted PSR. And that really boils down to get to the heart of this particular.
But it really goes to the question, how does that show agreement? And that's kind of what we're going around in circles about. We don't like to read out words and say they are superfluous when a statute or a guideline comes forth. You have a definition here that includes distribution element and the specific purpose element, but the agreed element has to mean something too. And all well and good, it just doesn't show that. And that's essentially, I keep pointing to the Sixth Circuit, it's just guidance if we take it at best. We're not bound by those other courts. But I mean, that seems to be, that word is in there. It has to mean something.
Even the first prong of the Oliver test, Your Honor, is agreed either explicitly or implicitly to an exchange with another person under which, and it goes on from there.
So what is the agreement here?
Well, Your Honor, I believe that it's agreed to an exchange, not necessarily
With another person.
With another person. And that was, again, getting back to the reason for the change was to narrow it down. So rather than just saying somebody is culpable if they're distributing, putting stuff out there, they are distributing to a person, which we know that Morehouse did that by his own admissions. He explained that he shared the aforementioned videos and images in order to receive other child pornographic images and videos from the unidentified users. He never contested this statement.
Is that an admission enough?
Yes, Your Honor. It's if absent, I mean, I do admit again that it would be nice if we had additional evidence in the record, but because of the nature.
That's your best quote, right? Just read that again so I can focus on it.
Morehouse further explained that he shared the aforementioned videos and images in order to receive other child pornographic images and videos from the unidentified users. He specifically.
Okay, I understand, but that's consistent with McManus, where you have a reasonable expectation of a return.
Well, and Your Honor, I would say evidence.
The question is that enough to be in agreement with another person?
I honestly, Your Honor, I would say that the fact that he did successfully receive images of child porn back is evidence that they're of an agreement of some sort. What that agreement is unclear.
They did it as a part of their practice. It's a site where you exchange various things, but there's no agreement between the defendant and another person for the exchange. And that's heightened in culpability, I suppose. At least that's where the guidelines want to go to.
And if I understand your question or statement, Your Honor, correctly, that again goes to the heart of the matter here, which McManus was forward thinking and abolishing that kind of open, free, peer-to-peer file sharing where you're not accountable for what somebody might just send you because your stuff is available. It added that level of culpability.
To purpose. It seems to me you are advocating a unilateral agreement here. It can satisfy this. And if that's so, the question is, how is that different from expectation of receipt?
I think, Your Honor, that the expectation that the language agreed to an exchange is unilateral. I think it's different from just a pure expectation because it has to be for, in this case, it has to be for a specific purpose of obtaining something of value, right? You can't just put something out there and hopefully expect something to get back. It has to be purposeful in order to receive.
There was an exchange, but where in the record does it indicate there was in fact an exchange?
Again, Your Honor, I'd point to paragraph 11 that Morehouse had the specific intent. Doesn't have to be successful. There's nothing in the
expectation. That's what we all agree on. He had that expectation. Beats McManus. The problem is you have a 2016 amendment.
Your Honor, I see that my time is almost up. May I close?
Respond.
For the reasons, Your Honor, The United States respectfully requests this court stand by its forward-thinking precedent, reaffirm the pioneering tests that set forth in McManus, upon which the commission modeled its 801 amendment, and affirm the judgment of the district court. Alternatively, should the court decide the McManus test requires some post-801 tuning, the United States asks the court to find sufficient evidence in the record, as did the court below, to apply the 2G 2.2 B3B enhancement based on paragraph 11 of the adopted PSR and Mr. McManus's unambiguous admissions that he distributed for the purpose of receiving child pornography in return. Thank you, Your Honor.
All right. Thank you, Mr. Osa. Ms. Biederman, you have some rebuttal.
Yes, I just have a couple of minutes. I'm just going to start with at the end of what the government was saying. And we agree with what he said at the end, that they were abolishing sort of an open share, and that he said that you have to agree to an exchange, but he left out the with another person. There actually has to be an agreement with another person to exchange. We do not have that here. He asked
to give him his argument. The question is whether I'm swayed or not is another question, but his argument is that there are other persons on that site. I mean, they're not animals and they're not robots. There are other persons on that site. And that's a reasonable assumption on his part, so that when he exchanges with unidentified individuals, that's another person. That's his argument, I think.
Well, you don't know that he's exchanged with other unidentified individuals. There is no connection between what he uploaded and what he downloaded. We don't know if he downloaded from the same sites that he uploaded to. We don't know where he got that from. We don't know if there was any sort of an exchange, and there is most certainly not an agreement with another person to that exchange. Now, there was an agreement possibly with the website that he was going to put these up there, but there was absolutely no agreement here with another person, and that those two people exchanged. There's no evidence that anyone that saw his photos then put up any photos that he then downloaded. And there's no evidence that there was an agreement and that it was because of those things. I will point out that the government did quote part of a sentence that I thought should be read in the whole, and that is when he talked about how the defendant distributed in exchange for any valuable consideration. It then goes on to say, the amendment further explains in the accompanying application note that this means the government agreed to an exchange with another person under which the defendant knowingly distributed to that other person for the specific purpose of obtaining something of valuable consideration from that other person, such as the child pornographic material, preferential access to child pornographic material, or access to a child. And there's absolutely no evidence that.
Where's that from?
That is from the amendment.
The notes?
Yes.
Okay.
Yes. The Sentencing Commission specifically discussed the Fourth Circuit's case in McManus, and this is under the explanation of that. And that's what we don't have here. And it's clear we don't have that here. For those reasons, we would ask that you reverse and send back for resentencing.
All right. Thank counsel. For us, this is the end of the week, and we go home, but we thank you for your arguments. We would normally come down and shake your hands. It's a wonderful practice that goes back to Judge Parker in the 1930s, and it's been sort of an identifying icon for the court. And we hate to suspend it, but circumstances, we're still under the protocols. So next time you come, we'll be sure to shake your hand and thank you. But in any event, thank you for your arguments, and we'll adjourn, I guess, to this afternoon, or what's the next court? Anyway, adjourn court with this session.
Thank you, Your Honor.
Yes.
Thank you, Your Honors.
This honorable court stands adjourned, signing by God save the United States and this honorable court.